record about procedural schedule and thoughts and just kind of have a conversation. Because I'm sure we have some ideas, you might have some ideas, and I think we might be figure out where we want to do. I think as an initial matter, we'd like to set a schedule for this case that would get an order issued by the end of the year. So that's kind of what we're looking at. It's a single issue. Our DER aggregators, public utilities. So we're looking at a procedural schedule that should be pretty limited and pretty tight, maybe with a hearing by August or September. It's a legal issue, so I was interested in what the parties thought about filings that they would make in this cause, if they had thought about it and what they anticipate wanting to do.
We've talked about it as a group, most of us, maybe some of us intervene later, but
if you might get on the microphone, just because we are streaming this and for people to be able to hear.
Yeah, we've kind of talked about it, most of us, and you know, one thing we wondered is if the commission wants testimony versus comments or legal briefs. And then the other related question might be, you know, since the definition of public utility status often is very kind of fact dependent, you know, do we want some fact testimony on what DER aggregators do and how they do it?
I think that's exactly what we were thinking as well. I think it's almost like motion for summary judgment type thing where you almost need a set of facts. And so I think whether it comes in as pre-filed type testimony or affidavits, just a way to get facts into the record that would support legal arguments as to whether or not those aggregators are public utilities, I think would be necessary. And I'll kind of defer to you all as to if you have a preference. I can see it happening both one of two ways, either everybody filing simultaneously and then filing responses thereto to the extent that they would like to file responses, and so you just have two filings, or it could be, as Mr. Davies indicated, where the aggregators and the utilities would file, and then we'd have all the other parties file, and then they would have the reply. I don't know that the commission has a preference one way or the other. I think it's a shorter procedural schedule if you do two filings and everybody has the opportunity to respond to each other's filings, given that it's a unique kind of case where, unlike other, where a particular utility is asking for specific relief.
Your Honor, from an Advanced Energy United's perspective, simultaneous filings would be preferable just because that way, because one of the things that council have spoken about is who bears the burden of proof here, and we don't think, I know the utilities don't want to bear the burden of proof, and I don't think the DER aggregators want to bear the burden of proof either, so I think this is more a proceeding where we can offer facts into the record and take positions on what those facts mean from a public utility status perspective.
I just note the testimonial staff agrees with that position. We think it would be most expedient and efficient to file simultaneously.
I think, speaking for I&M, and I'm looking around at my utility council colleagues, I think we're all fine with that.
Yes, okay.
Works for us too.
Do you want to think about dates and talk about dates for doing that? Having an initial filing and then a second filing?
And you're looking at a hearing, you said end of August, beginning of September?
At the latest, I would think, in order for us to get an order out by the end of the year.
Yeah, we were on a slower schedule, so give us a minute to maybe put our heads together. So we and David will file first. So David, did you have a target first date?
Your Honor, I think the commission's calendar's fairly full at the beginning of September with another big case, so
It-
I know you do.
We do. But I'm not expecting the hearing to be real extensive for this one, unless you all think there's going to be an extensive hearing and cross-examination of testimony would file in this. So I don't know that it would require an extended period.
Right.
So it'd be easy to slip in amongst the other.
Well, that was going to be my question to you, given at least what my client knows about the calendar at that time of year. Would you prefer August, or would you prefer, or just wherever we can slide it in?
I mean, if everybody can make their filings to us so that we could do it by the end of August or mid-August, I'm happy to do that. Earlier is always better for us. If you want to move this along quicker, that'd be great. If you need more time, then we'll make it work.
Yeah. Yeah, maybe like initial filings July 10th or 11th or 12th.
And still do that late August hearing, right? We could do the July 15th.
August 10th, and then maybe end of August.
And then a month, 3 weeks or a month for a response. Yeah, expedite the response.
What about like July 10th, August 10th, and then end of August?
See, that's, I mean, we need a little time, I guess, to digest the filings before the hearing, of course. But even still, a couple weeks should be.
Your Honor, how much time would you want between the second filings, or the responsive filings, I guess, so we'll call them now, in the hearing? At least 2 weeks, 3 weeks?
I think I'm more concerned with the time between the responsive filings and the hearing.
Yeah,
than I am-
did I not say it that way? That's what I meant, the
Oh,
responsive
okay.
filings and the hearing.
Sorry,
My
I thought
apologies.
Initial filing, responsive filing.
No, sorry,
Really don't-
responsive filing and the hearing. I probably misstated it. That's what I meant. I
I
apologize.
misheard, sorry. Staff, I'm looking to staff as to how much, at least 2 weeks. 3 weeks wouldn't hurt, but yeah.
And Judge, if I could ask another point of clarification. When you appointed testimonial staff in the order, that appointment was made pursuant to 81251, which is the commission's investigatory agent provision. And I guess I just wondered, was the commission expecting sort of a usual testimonial posture here, or is there something else that the commission was expecting of Ren Norman as an investigatory agent? I wasn't sure if you meant sort of an 8115 appointment or something different.
I think we were just looking for testimonial staff to participate.
Testimonial, fair enough.
Yep.
Thank you.
And not to complicate matters further, but I think for all the parties to be on the same page from a factual perspective, would a virtual technical conference be something the commission might entertain in June?
We would entertain that.
Okay.
That would be helpful.
From Advanced Energy United's perspective, a technical conference would be helpful.
So we were just talking about July 15th for the initial filings, August 5th for the responsive, and if the commission could have a hearing the last week of August. And then to David's point, if there's a technical conference sometime in June.
about August 27th at 9:30 for a hearing? And then a technical conference in June. You've got Mark, you're gone at Mark, aren't you? Oh, you're not going to Mark? Okay. Yeah, that might. June, so June 10th, 11th, or 12th? 11th is wide open. How does June 11th in the afternoon work for people? Afternoon sufficient too?
Your Honor, can I ask a point of clarification about the technical conference?
Sure.
If we're going to have a virtual technical conference, so a virtual technical conference, will the commission, when issuing its docket entry, will it put some guardrails around what exactly the presentations during the technical conference will present? Like specifically, I would think that we would want to hear about the aggregator's business model, or how they interface with customers, things like that. Will that be spelled out, or will it just simply be open to whoever wants to presents?
I guess I'd like to know a little more about why holding a technical conference. What do people want to accomplish at this technical conference?
I think the technical conference will help all the parties understand better what the factual circumstances under which DER aggregators conduct their business.
Say that again?
So I think having a technical conference will allow the DER aggregators, or those representing them, like trade associations, for example, to talk about what DER aggregators actually do and to help frame the factual issues for an eventual order in this cause and for the testimony.
So you're looking at it as the DER aggregators would provide information to the other parties? Is that what you're looking for?
I think that's part of it. And then the other parties are also free to provide information that for example, if the utilities have experience with DER aggregators and acting in a certain way, that would certainly be within the bounds of what the technical conference could entail.
I guess when I've done technical conferences, it's not been so much asking for a presentation from the parties, because we will get the information in the filings that comes to us, and it's been more as an opportunity for parties to talk to each other with the commission present. That way we avoid the ex parte rules, about questions or things that they don't understand and wanting to clarify that they may not have information about. Like, so, for example, if Duke doesn't understand what a DER aggregator is because they're not an aggregator, but your clients are aggregators, they would have that opportunity to talk to them about information that they wouldn't have at their disposal. And so that's what I would think is more technical conference appropriate. And that way we're not getting into presentations of here's my case in chief or here's my direct testimony type of circumstance.
I agree with that, Your Honor. The other piece of the technical conferences that I've been a part of is hearing what the commission wants to hear from the parties. And so, for example, in a recent investigation, the commission, Mr. Thomas spoke about what he wanted to get from the parties during the presentation of evidence. And I think that was helpful in framing the issues that were presented in testimony.
And I guess maybe that situation is just slightly different in that I think we've got a pretty narrow issue in that an investigation order that we issued, we basically said the one thing that we want to look at is are aggregators public utilities or not? And so it's a very narrow legal issue, unlike some of the other cases where we're looking at it from a fact-specific situation.
And I think the virtual nature of what we were proposing helps alleviate at least some of the burden on the parties for actually coming downtown and sitting in this room. And if it only takes 30 minutes, it's just 30 minutes, and there's not the associated travel and things of that nature.
Your Honor, I'll just add, my client and myself sat through the commission's stakeholder process that they had around the rulemaking all last year, and as obviously we've been monitoring this issue. So I think we're comfortable on what DER aggregators are. I don't know if we would necessarily feel the need for a technical conference. So I just want to put that out there. I mean, we're not opposed to it, but I don't know if we see the need for it from our perspective.
And I guess just following up on that point, on our commission website regarding the implementation of FERC Order 2222, there are currently 4 slide decks and 2 sets of comments from DER aggregators, which could well provide the background information that parties seek. I also don't object to a technical conference, but I did want to add that information to Andrew's comment.
The one additional thing I would add to the conversation is, I know Mr. Davies talked to a couple aggregators, but to the extent to which they don't formally intervene. I know AEU has aggregator membership, but that a technical conference would at least provide them that opportunity to be more involved in the process. But we're open.
And I think from if the technical conference materials are going to become part of the record at all, I think we would probably object. We would object to non-interveners presenting evidence.
A technical conference is only for parties. That's if they choose to intervene, that's great. This is not a public participation process. This is a commission investigation, and if they want to intervene in this proceeding, that's fine. We'll entertain any petition to intervene, obviously. But the technical conference, because it is part of this docketed proceeding, would be open only to parties' participation.
Thanks for that clarification.
I think for now, we'll go ahead and set it virtually, a technical conference for a virtual technical conference on June 11th. And as we'll talk internally too, and as we get closer, maybe we can decide and let you all too talk and see whether you believe it's necessary or would be beneficial to the commission for us to hold a technical conference or not. You can provide us additional information, but we'll leave it scheduled for now and at 1:30 since we've got the date. Who knows what our calendar will look like between now and then. So we'll do that. one more thing before we go on the record too that I wanted to talk about was, I have petitions to intervene from several parties. I don't know if you've all had a chance to look at them. I got a petition to intervene from Southern Indiana Gas and Electric, Wabash Valley Power, Hoosier Energy, Citizens Action Coalition, and Advanced Energy United. I intend to address these on the record. Are there any objections? There's a few that have just come recently. Any objections to those petitions to intervene by anyone?
No.
No, Your Honor.
That'll make it easy.
And can we address again at some point, like, let's say, we all agree on what an aggregator is and what they do, but the remainder of whether it's testimony or comments might be kind of a pure legal issue. Is it okay to file comments on that rather than testimony, or would you prefer testimony?
I think it would be appropriate, both in the initial filing and the responsive filing, if you want to file both testimony, affidavit, and a brief. I think it would be appropriate given the legal nature of the issue that we're making a determination on.
Great, that helps.
And just to clarify, is it and/or a brief, or do?
Yes, and/or.
Okay.
Whatever you believe is necessary to, if you think there's, but we have sufficient facts on which to base our decision, and all you need is a legal argument, well.
Okay. Thank you.
Do you want to talk about proposed orders now, or do you want to wait until after at the date of the hearing? Sometimes people's schedules change, so. Okay. Why don't we just do it at the hearing time then? That way I don't have to write something else down. Doesn't work. All right. Anything else we need to discuss before we go on the record?
Your Honor, Michael Griffiths, my client has not yet intervened, and we're still trying to decide if we want to intervene. Discovery rules, are you envisioning normal discovery would apply? So if they do intervene, will you be subject to the normal discovery process?
That's, unless you all want to agree to something else while I'm sitting here, then otherwise the commission standard discovery turnaround time, which is what, 10 days, 10 business days, or whatever our standard discovery is. And if you all agree to something else, that's up to you too. Any other questions? Okay, let's go on the record then. Linda, you all ready? This is a pre-hearing conference and preliminary hearing before the Indiana Utility Regulatory Commission in a cause docketed before the Commission as cause number 46043, captioned as in the matter of the Indiana Utility Regulatory Commission's investigation into the public utility status of distributed energy resource aggregators. Notice of the time and place of the hearing was given as provided by law by publication in Marion County in the Indianapolis Star on April 23, 2024, and in Hendricks County in the Hendricks County Republican on April 25th, 2024, and in Lake County in the Post-Tribune on April 26, 2024, and Northwest Indiana Times on April 22, 2024. In Vanderbilt County in the Courier and Press on April 24, 2024, and in Allen County in the Journal-Gazette on April 20, 2024. These are newspapers of general circulation, and the publications were made at least 10 days prior to the date of the pre-hearing conference and preliminary hearing. The proofs of publication of the notices have been received by the Commission and are now incorporated into the record of this cause by reference and placed in official files of the Commission. Notice has also been given to the Indiana Office of Utility Consumer Counselor and other interested parties. May we have appearances, please?
Good afternoon, Your Honor. Steve Davies, Senior Assistant General Counsel here at the Commission, and on behalf of testimonial staff, Ren Norman.
Thank you, Your Honor. On behalf of Indianapolis Power and Light Company doing business as AES Indiana, Jeffrey M. Peabody.
Thank you, Your Honor. On behalf of Duke Energy, Andrew Wells.
Thank you, Your Honor. Please accept the appearance of Jennifer Washburn on behalf of Citizens Action Coalition of Indiana.
Good afternoon, Your Honor. Appearing on behalf of Northern Indiana Public Service Company, LLC, please accept the appearance of Tiffany Murray.
Appearing on behalf of Indiana Michigan Power Company, Kay Pashas with the Taft Law Firm.
Good afternoon, Your Honor. On behalf of Wabash Valley Power Association, Inc., Jeremy Fetty, Par Ritchie.
Thank you, Your Honor. On behalf of Advanced Energy United, David McGimsey, Denton's Bingham Greenbaum, Jasper office, I'd also offer the appearances of Laura Mannion, Zachariah Banks, and Ryan Mann of Denton's Bingham Greenbaum, Indianapolis office.
Thank you, Your Honor. On behalf of the Office of the Utility Consumer Counselor, Scott R. Jones.
Thank you. And I have received, the Commission's received petitions to intervene by Southern Indiana Gas and Electric Company, Wabash Valley Power Association, Hoosier Energy Rural Electric Cooperative, Citizens Action Coalition of Indiana, and Advanced Energy United Incorporated. And it's my understanding that there are no objections to any of these petitions to intervene, correct?
Yes, Your Honor.
Thank you. Then those petitions to intervene are granted. And before we went on the record, we had a brief discussion about the procedural schedule in this case. And the parties have agreed that we will hold a virtual technical conference on June 11th at 1:30 p.m. Any party wishing to make an initial filing shall do so by July 15, 2024. Any response to any initial filing shall be filed by August 5th, 2024. And we will hold an evidentiary hearing in room 222 on August 27th at 9:30 a.m. Anything further we need to discuss? Okay, hearing nothing further, we're continued to the evidentiary hearing on August 27th, 2024. Thank you.
Thank you.